Hello and welcome to today's web seminar, How to Analyze Contracts, Avoid Surprises, and Protect Your Trucking Business. Today's web seminar is brought to you by Cline University with special guest speakers from Great West Casualty Company, Robert Todd, Esquire, Manager Legal and Subrogation, and Jonathan Stringer, Esquire, a cargo claims attorney. Before we begin, I'd like to briefly talk about the technology we'll be using today. All of your lines have been muted for the duration of the web seminar. However, you can enter any inquiries that you have at any time via the question box or chat box, and we'll queue them up for the conclusion of the presentation. You can also slide the GoToWebinar box closed by clicking the orange arrow or double arrow, but do not click the black X or you will exit the web seminar. Without further ado, please welcome our first speaker, Robert Todd.
Thank you, John. This is Robert Todd, and I thank Cline Wood for inviting us to talk about this exciting topic. It's scintillating, keeps you awake over the lunch hour, contracts and cargo provisions. This should take about 15 to 20 minutes on my part, and then Jonathan Stringer, another attorney, will talk about some cargo claims. As a little background, Jonathan Stringer is a cheerful one on the page, and Great West Casualty Company hired me from the eastern part of Iowa, western Illinois, where I practice law in a general practice representing small companies and businesses, and suing insurance companies and suing truck companies and all that. And this is my second career and representing Great West and doing contracts for Great West Casualty and its underwriters. Now, contracts and contract review are about like getting your teeth cleaned, and it is necessary, and it can be exciting, especially after the fact. Here's an interesting picture that I thought I'd show you. It's a beautiful ship, making lots of money on it, and the Costa Concordia, you probably all remember that in the news a couple of years ago, and it had an Italian captain, and the Italian captain was driving along apparently, and this is what happened to him, and there it is. And this is relevant to our contract discussion, believe it or not, and because it exemplifies a lesson I think we have to live up to and face, especially when it comes to reading contracts. Don't take any shortcuts. And that's kind of reminds me of the lesson that one of the survivors of the Donner Party said. And he said, "What'd you learn about that after surviving that winter?" And the survivor said, "We learned not to take no shortcuts and not to tarry, because otherwise you'll eat your uncle," or something like that. But anyway, contracts are about the same way. You can't tarry, you can't take any shortcuts, and you've got to read them. And I know nobody wants to read them except for the provision concerning price. Of course, you've got to read that, but you've got to read a few other things, because there's no limit to what you'll find inside these contracts. And if you sign it, you're presumed by the law to have read it. And the attorneys draft these contracts, and I know I've been there, I've done that. They draft the contracts so you don't understand it, so you don't read it. That's the whole point of this, to get somebody to sign a contract. This is the point from an attorney's point of view. The whole goal of writing a contract is to get the other party to sign it, and they don't realize what they've signed, and now you've got them. And so there's a couple issues in these contracts besides price. And that's what I'm going to talk about briefly today: indemnification language and the insurance requirements. And then Jonathan's going to talk about damage to cargo, liability standards, damage measurements, and delay and consequential damages. And the reason I'm going to talk about indemnification first, and I'm not going to go all through this today, but the indemnification language really determines in large degree the expectations of the parties, the expectations of a shipper or a terminal, and that also impacts the insurance requirements that the shipper is imposing upon you, the motor carrier. And if you don't understand the indemnification language, you're not going to understand what the insurance requirements are going to be. And then also the contracts do set up liability standards and damage measure for damages to cargo. And I mentioned delay and consequential damages because that's not covered by the Great West cargo policy. And you have to be sure that you do not create a contractual liability for yourself in the contract by agreeing in the contract to pay for delay and consequential damages. So once again, there's no shortcut to reading these contracts, and if you do take a shortcut, you're going to end up like the Costa Concordia. And I picked that Costa Concordia picture because we're in discussing indemnification language and clauses. We're going to see a specific indemnification clause in a minute here. But what is indemnification? Is it paying for another's negligence? Sometimes. Hopefully in the indemnification clause, you basically agree to pay for the damages that your negligence causes to your business partner, to the shipper. And that's the kind of loss that you have bought insurance for. So the insurance company pays for your negligence, and that's typically what the casualty policies are intended to do. But a casualty policy is not set up to pay for your breach of contract generally. In fact, the contract policy, all these casualty policies, have one primary exclusion. Usually it's exclusion 2 or 3 in all the policies, and that's contractual liability, because these policies are not contract performance bonds. But some of these indemnification clauses go as far as to make the motor carrier agree to pay for the damages caused by the negligence of the shipper. And that's the way I start this slide out, with paying for another's negligence. Is that in the indemnification clause? Now, I'm going to give you a clue to reading indemnification clauses. Read it backwards. Now, let's look at an actual indemnification clause. There you go. This indemnification clause has actually been imposed upon many motor carriers, and you see it if you're in the intermodal business. And in fact, it's the indemnification clause that the salvage company, it belongs to the salvage company who is actually now salvaging the Costa Concordia. It's a huge global company, and this is what they impose upon their motor carriers. And as you can see, that massive paragraph, it's just almost impossible to read. And in fact, most attorneys don't really read it from the beginning to the end. And why? Because, as I said before in the prior slide, the attorneys read it backwards. Now let me show you how an attorney reads the slide, and it'll save you a lot of time and trouble. And if you can see the second to last word on this paragraph, that's the key right there. And here, look at this. This is the same paragraph now, but I've enlarged some words. And look at the second to last word, the word sole. And basically, in the last part of the paragraph, it gives the motor carrier a way out where the motor carrier does not have to indemnify the shipper. And in this case, the motor carrier does not have to indemnify C Corporation, the shipper, when the loss is caused by the sole negligence of the shipper. And that basically never occurs in this day and age of comparative fault, because there's always 1 or 2 people involved, and therefore the shipper and terminal will never be solely at fault. And once you see the words sole negligence at the end, you can look up and be guaranteed 99 times out of 100, you're going to find these clauses 1, 2, and 3 above, in the indemnification clause. They're buried in there so you don't see it. And these are the 3 red flags, 1, 2, and 3. The first red flag is you're going to indemnify and pay for any and all loss. That just covers absolutely everything. 2, arising, you see the word arising out of the carriers having control. And 3, possession. And sometimes you'll see the word actions or acts. And an act does not have to be a negligent act. Just anything you do, if it causes any damages or liabilities, you have to pay for it, even if it's a non-negligent act. And there was another participant in this action, namely the terminal, the shipper, who was negligent, you still have to pay for it completely. And so you can easily determine whether the indemnification clause is going to require you to pay for the damages caused by the shipper's negligence. If you read the indemnification clause backwards, look for the word sole, and if you see sole negligence, and if you see that word there, then you guaranteed, if you look above, you'll find these 3 red flags: any and all damages or losses, the word arising, and the word possession, or sometimes it'll say acts of the motor carriers, acts or omission, but it will be very broad. Now this also shows what kind of protection the shipper or terminal is expecting from the motor carrier when it asks the motor carrier to name the shipper or terminal as an additional insured on their policy. A paragraph like this, an indemnification clause like this, shows expectations that the shipper or terminal is protected from its own negligence. And when it asks to be an additional insured, with no further discussion of the scope of coverage for the additional insured, this kind of broad indemnification clause indicates the broad expectations of the additional insured endorsement. And they basically want the motor carrier to have an additional insured endorsement that ensures the additional insured's own negligence, namely the additional insured endorsement to pay for the damages caused by the negligence of the additional insured. And that shifts the loss away from the additional insured onto the motor carrier's policy. Number one, if that happens, it could increase your insurance rates for the next year. Number two, if the motor carrier has a self-insured retention, where it retains the first $50,000 or $100,000 worth of loss, then that gets shifted back to the motor carrier, and the motor carrier has to pay for it out of their pocket. So it's very important that these expectations be identified up front by an analyst and by analyzing the additional insured endorsement. Now, how can we correct this? Well, you can't delete the entire paragraph. That's impossible. But here's three ways to easily fix these indemnification clauses. First, you could arrow in with a little caret at the very beginning of the indemnification clause, the little phrase, to the extent of the carrier's negligence. And now you're tying everything clearly and specifically to the carrier's negligence. And always in the rules of interpreting contracts, annotations take priority to typed language, especially when you can show the proof that the shipper or terminal has agreed to it. And you need to get proof of that, by the way, and we'll get to that in a second. Number two, another way to fix this, cross out the word sole. And that means that you don't have to indemnify the shipper for losses caused by the shipper's negligence. And that's an easy solution. Just strike out the word sole. But you've got to get some written evidence that they agree to striking the word sole. So you've got to ask some responsible party on the shipper's side, hey, let's just strike the word sole, and send the email confirming that we all agreed to strike the word sole, or get their initials on the side of the piece of paper. And the third way is at the very end of the indemnification clause, write a little arrow before the period and stick in the words, the foregoing indemnity does not apply to the extent caused by the shipper's or provider's negligence. And this basically says, whatever is said above, it doesn't apply to losses caused by the shipper's or terminal's negligence. Now, once again, you cannot make these changes and try to sneak them over to the shipper or terminal and not tell them that you've made the changes. You need to tell a responsible party up front, send them a letter or email or a fax confirming that we all agree to strike the word sole, for example, and then you sign the contract, strike the word sole, and email it back or fax the contract back. And it's a little tedious, but it has to be done. And it makes it much easier to correct these problems in the beginning, and by taking the time to go through these indemnification clauses and changing them and fixing them. Next, what if the contract can't be fixed? And the terminal shipper says, no way, we're not striking anything, we're not adding anything. It's as is, live or die, which frequently is said. And the motor carriers just have to suck it up. But if your contract requires you to pay for the damages caused by the shipper to another person, and that 9 times out of 10 is your driver, you have coverage. You have coverage under your policy, under the general liability policy and the auto liability policy, and it's called insured contract coverage. And part of the definition of an insured contract coverage is that, and this is actually in the insurance policy, it says that, and I'll shorten it up, it says basically if you, the insured, agree in the ordinary course of your businesses to pay for the damages caused by the negligence of another, the tort negligence of another party, to a third, then that will be covered, and that coverage is called an insured contract coverage. And the reason you have to have that coverage is because contractual liability is generally excluded from the policy, with one exception, for those losses that are covered by the definition of an insured contract. So if you can't get it fixed, you don't have to push back too hard, but you have coverage. And the policies are there to protect you, but we don't want these losses shifted onto the transportation industry, losses caused by the negligence of the terminal, because it just drives up the cost of business. It drives up the cost of insurance. And if you have a self-insured retention agreement, of course, you'll feel the pain along with the insurance company. Now, some other contracts or insurance policies do not have insured contract coverage, but they have similar coverage, and they call it contractual liability coverage. and that's those same policies exclude contractual liability. But ISO-based policies, that's Insurance Services Organization, and now short just to ISO, they decided about 40 years ago that sounded difficult. You exclude contractual liability coverage, and then you give contractual liability coverage. So the ISO policies exclude contractual liability with one exception for those losses that fit the definition of an insured contract. So you have insured contract coverage. Many insurance requirements confuse those two things. Also, sometimes I think people drafting these insurance sections believe that general liability policies especially can perform as contract performance bonds, which they do not. Now, if you can't fix it, nowadays we have many state anti-indemnity statutes for the protection of motor carriers and the protection of the driver, frankly. Missouri has an excellent statute. Kansas has an excellent statute. And these statutes make it void by public policy any indemnification clause that requires the motor carrier to pay for the damages by the shipper or the terminal. And it's automatically void. And it's void in the contract, and it's void in your insurance policy. So if you have to buy an additional insurance endorsement to cover the negligence of the additional insured, this statute will strip that coverage out of that endorsement, and it will strip your contractual liability out of the indemnity clause, and that will protect both you and your insurance company insuring motor carriers and help keep the cost down. In addition, without doing that, it is truly hazardous to public policy because the terminals and the shippers have no financial incentive to be careful and avoid injuring the drivers, because we're talking about injuries to the drivers 9 times out of 10. They're getting run over by forklifts, the stairways are collapsing, there are potholes and all kinds of problems. So it's very important. And you've got a couple of good states there. Most of the states have these anti-indemnity statutes now recently, and so we can take advantage of them. The statute you can determine by reading the very end of the contract. Read the contract backwards like an attorney. Most contracts near the end of the contract, by the last page usually, they will select a state by whose laws the contract will be interpreted. And hopefully they'll select a state that has one of these anti-indemnity statutes. And if it has a bad state like Delaware or New York, ask them if you can change it to your home state, to Missouri or to Kansas, to Iowa, Illinois, and then see what you can get done. You can't get something if you don't ask for it. That briefly is my presentation about indemnity clauses and insurance coverages, insured contract coverages. And I'm now going to, one thing I forgot to mention, what was not excluded from that prior indemnification clause, cargo. And once again now, the question is, has the motor carrier waived its 5 Carmack defenses, which I'm sure everybody knows what those 5 defenses are? And does the contract otherwise have a separate paragraph describing the cargo liability regime? And with that, getting into the cargo liability, now it's time for Jonathan Stringer to take over and finish the program. Thank you. Jonathan?
Thank you, Bob. My name is Jonathan. As Bob said, it's a pleasure to be here with you all today. And as Bob indicated, I'm here to talk about cargo. I came to Great West about 3.5 years ago. Prior to that, I was in Chicago, where I was in private practice for about 10 years, defending various entities and handling cargo claims. As far as cargo liability goes, the bread and butter of cargo defense and cargo law is the Carmack Amendment. As most of you probably know, the Carmack Amendment, you only got to do 3 things. Say that you, as a shipper, you gave the cargo to the carrier in good condition, it arrived in bad condition, and damages. So those are your basic elements for a cargo claim. And with that said, it's somewhat easy for a shipper to establish a cargo claim, but it's becoming more and more complicated nowadays because of all the contracts that we're seeing. And with that in mind, I thought I would highlight this case that just came down recently this year, which you see on your screen, UPS v. Megatrucks. This decision came out, I believe it was in May of this year, and it came out of the 11th Circuit. The 11th Circuit Court of Appeals is out of Georgia. So we're talking about really the southeastern portion of the country. but it is a Court of Appeals decision, which means it's going to be very persuasive in terms of application to other claims and other cases that will go through the courts. So let's get into this case just briefly here. It's a situation that is pretty common nowadays. You had a shipper who contracted with essentially a logistics provider, UPS. UPS, in turn, gave it out to a carrier, Megatrucks. Well, then Megatrucks subcontracted the shipment to someone named Stallion. So what we have here is, again, the original shipper giving it to UPS, UPS giving it out to the carrier, Megatrucks, and then Megatrucks essentially subcontracting it to another carrier. Well, the shipper had a contract with UPS, and it allowed UPS to subcontract out shipments to third parties. And it had a limitation of liability that applied, and not only did it say it limited the liability to UPS, but it also applied to its subcontractors, and the limit of liability was $100,000, except where loss was due to gross negligence. So, you know, on its face, it appears to be something where, okay, if there's an incident here involving this cargo, the liability should be $100,000. Well, here's what the contract provided. This is from the actual contract at issue. And again, this is the UPS contract with Megatrucks. And you see in the first part here on your slide where it talks about liability. The liability is for the full liability for risk of delay, loss, or damage to cargo. So essentially now we have liability that is for the total amount of whatever cargo damage we have. You then had an indemnification paragraph that said the carrier, i.e. Megatrucks, would indemnify and hold harmless UPS from and against any and all loss, expense, damage, injury, or claim, including attorney's fees. So that's the contract here. Again, you had UPS who had a contract with the shipper establishing a $100,000 limitation of liability to UPS and its subcontractors. But then you had UPS turning around and contracting with Megatrucks for full liability and indemnification. Well, the load was stolen. Even though UPS had that $100,000 limitation of liability, they paid the shipper $246,000. The shipper assigned to UPS all their rights, claims, and causes of action against Megatrucks and any others arising out of the loss. What I think was unique here, and somewhat uncommon, if you will, was that under the assignment provided that any sum recovered in excess of the amount that UPS paid, that is the $246,000, would be payable back to the shipper. So now UPS hauls Megatrucks into court for liability pursuant to the Carmack Amendment. That was what I mentioned a few moments ago, which I think most people here know. It's almost a strict liability standard where you have those three basic elements that you need to show. I gave it to you in good condition, it delivered in bad condition, and these are my damages. They also sued, though, for breach of contract and the indemnification under the breach of contract. Well, Megatrucks did what I think most other carriers would do, and they asserted that the liability would be limited to $100,000 under the contract that UPS had with the shipper. After all, you had a shipper who agreed with UPS that liability would be limited. The result, UPS was entitled to recover the full amount of the actual cargo loss. It was $461,000. More so, UPS was also entitled to get their attorney's fees. The Court of Appeals remanded it back to the district court to determine what those attorney's fees would be. Those attorney's fees fell into that provision of the indemnification in the contract. And I can pretty much guarantee you those attorney's fees are probably going to be $100,000, if not more. So essentially what you had here was UPS paying out, $260,000, yet recovering from Megatrucks, the carrier who they gave it to, and actually then subcontracted out to Stallion, $461,000 in attorney's fees. This is a negative decision. You know, the effects of this, it basically allows logistics providers, i.e. brokers, to limit their own liability to shippers on the one hand, while at the same time maintain a right to go after the carrier for essentially unlimited damages. I say unlimited, but it's the actual loss or value of the cargo, which is greatly more than what the limitation liability was. More troubling than that, from a legal perspective, you basically had a situation where they combined Carmack Amendment and the contract. You know, it should have been one or the other. It shouldn't have been both. But this court essentially said, you know what? Yeah, you have the strict liability of Carmack Amendment, and we're also going to allow you to get attorney's fees under the contract. So this is a very troubling decision. It's not clear why the provisions of the contract limiting the liability of UPS were relevant to the court when UPS relied on its assigned rights of the shipper under the Carmack Amendment to go after megatrucks, but that's what it did. So a negative decision. Hopefully it won't be followed in the other courts of appeals in the 5th District, which is Texas, 8th District, which is up in Minnesota, Nebraska, Iowa, and the 10th Circuit, which is Colorado, Kansas, etc. So with that said, I wanted to just convey the significance of that decision and to be aware of that. And then the last thing I want to talk about here is the Food Safety Modernization Act. Based upon my experience, I found that a lot of carriers out there are not aware of what's going on with respect to food regulations. As many of you know, the Food Safety Modernization Act was passed a few years back, and under that act, they required regulations be passed to essentially regulate the transportation, the sanitary transportation of food so that it doesn't become adulterated. Recently, proposed rules were published. These rules are proposed, they've been published by the government, and they are accepting comments on them. The last comment period just expired July 30th, and hopefully they will further revise the rules. But it's important for carriers to be aware of this now and get a jump on it before these rules come into play. When will they become final? It's uncertain. We're talking about government here. Usually these things go through quite an extensive period of comments, and you know, it could be 2 years, it could be 5 years, it could be next year. I think it's probably going to be 2016, but it's uncertain. Where can you find this? If you look on your screen, I've put on here where to find them. The legal site is 79FR 7005, but I've also provided a web link, www.regulations.gov, that you can find a copy of these proposed rules. I put a search in there. It says ID FDA 2013. You'll see that completely on the slide. If you do that search on the regulations.gov website, you'll pull it up and you'll be able to see what these proposed rules are. Now, I want you to also note these proposed rules do have an exemption. They don't apply to carriers with less than $500,000 in sales. However, the FDA determined that 98% of carriers will be covered by these rules. So please just take a look at these. I'm going to go into what these rules are about very briefly, but in no means is this a complete review of these rules, just some highlights of what's going on to give you a heads up and try to get ahead of this. As I referenced earlier, these proposed rules are to ensure sanitary transportation. It's to basically ensure that food is not transported under conditions that render it adulterated. They seek to establish criteria to basically give guidance as to what would be considered adulterated. Currently, we see a lot of cargo claims where you have shipments that we think there's otherwise nothing wrong with them, and many times the broker or the receiver, their last fallback position is if they can't really prove the damages, they'll say it's adulterated. They will insist that it be destroyed, and it's becoming more and more common. These rules that are proposed rules, if you will, that are coming out are going to be negative, I think, for the motor carrier industry. So what will the effect be? Well, right now, as far as operations go, it basically provides that you have to supply a vehicle and transportation equipment that meets the requirements specified by the shipper. They also say, and is otherwise appropriate to prevent the food from becoming adulterated. So you get some wiggle room there. The FDA wants you to pre-cool each refrigerated unit as specified by the shipper. Well, in the month of August, and you need to pre-cool a unit for ice cream, it's going to be next to impossible to get that unit pre-cooled down to minus 20 degrees. I think most carriers understand that. You also have a provision in those proposed rules that once the transportation is complete, the carrier has to demonstrate to the shipper, and if requested to the receiver, that temperature conditions were maintained consistent with those specified by the shipper. That's very significant. You're essentially turning the Carmack Amendment on its head, and essentially you have a Carmack Amendment that has the burden of proof on the shipper. They're almost turning that around, inverting it, and putting the burden of proof now on the carrier. It is not going down lightly right now in terms of those who are aware of these rules, and hopefully, as I said, there has been a comment period on these. Comments were submitted. Hopefully revisions will come, but right now these are what the proposed rules say. Not only is it on operations, it's also on training. Carriers have to provide training to personnel that provides an awareness of potential food safety problems. The training must be provided upon hiring and is needed thereafter. Not only that, carriers have to establish and maintain records documenting the training. So again, you have the government stepping in, telling you what you need to do, how you need to run your business here. I think the common sentiment is the onus should be on the shipper to convey the requirements to the carrier because this is their product. They know the product. Again, you have here where these rules are kind of inverting that and basically putting the onus on the carrier to make sure that its employees have the requisite training. There's also a record requirement. Carriers have to retain written agreements for a period of 12 months beyond when the agreements and procedures are in use in their transportation operations. So now you have a 12-month requirement, which appears to me to be burdensome for the carrier and probably longer than what it needs to be. Not only do you have this record retention requirement, but it says that the shippers and carriers must make all these records required by the rules available to a duly authorized individual promptly upon oral or written request. So again, you essentially have onus being put on carriers for their operations, for their training, and for their records. And it is a very good time now for carriers to take heed of these proposed rules, try to get ahead of the curve, and take a look at them because they can seriously implicate the operations of those of you who haul food. So with that said, I'm going to turn it over to the moderator in the event that there's any questions, and thank you again.
And thank you, Jonathan and Robert, both, for sharing all that important information. We do have several questions that have come in. We'll go through a few very briefly with respect to everyone's time. So how can I, as a carrier, limit my liability for cargo?
I think that's Jonathan's area. Jonathan?
Yeah, that's an excellent question. It's a question that I get quite frequently from a lot of our insureds. Essentially, there is an established way that the courts have looked at this in terms of doing it through a bill of lading. The easiest way that you can do it is through a contract. If you're going to sign a contract with a shipper to move their cargo, have a paragraph in there that says your liability is going to be limited for cargo damage to a certain amount. You can make it the limits of your insurance, say $100,000. You can make it $20,000. Again, it's a contract. You can agree to with what you want. The other way you can do it is through bills of lading. The traditional rule is that you give the shipper a chance to pick between full liability and a liability cap, and you get their agreement to the level of liability and then issue a bill of lading. A practical way that this is accomplished, when you submit your rate to the shipper, just tell the shipper, hey, this rate is based upon a $50,000 limitation of liability. Shipper, if you want a higher limitation of liability, you need to ask, and I will quote you a higher rate. Document it in writing, a rate confirmation, an email exchange, anything else showing that the shipper basically had a choice and chose a lower level of liability. It's not right for motor carriers to basically assume that they're giving them the lowest freight rate they can on the presumption that the shipper knows their liability is only going to be to the extent of their cargo policy limits. It's not going to save you. So that's the answer to that question. Thank you.
Another cargo-related question we have is, if I receive a load and they know my cargo insurance is for $100,000, wouldn't my liability be limited to my policy limits for a cargo loss?
That's also another one that I'll field. It's a good question. It's a common question that I get. No, your liability would not be limited to your insurance. It's a common misperception. I hear it a lot from insureds that say, well, the broker knew I only had $100,000 in limits for cargo policy limits, but they gave me this $250,000 load. Unfortunately, the courts are not going to hold your limit of liability to your policy limits. There's only been one court in the country that's done that, and it was somewhat of an anomaly down in Arkansas a few years back. And again, it was an anomaly, and it's an argument that's presented a lot, but unfortunately the courts aren't going to buy it.
Well, thank you, Jonathan. And once again, we thank everyone for attending today. Please be looking for future Clinewood University web seminar invitations. If you would like a copy of the PowerPoint presentation, or if you have additional questions, please reach out to Clinewood. Their contact information is on the screen, or reach out to today's speakers from Great West. With that, this web seminar is now ending. We hope you all have a great day.